From a man battling drug addiction while facing assault charges for attacking hospital staff.
Did you understand you're charged with assault of a hospital personnel? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
To another facing charges for possession of controlled substances.
All right, so he was discharged unsatisfactorily from IOP, and then he was sent to felony drug court, and he just wouldn't stop using drugs.
Marijuana, correct, Judge?
Well, I know it's 2024, but there's an admission to cocaine from your client.
Here are 5 moments where Judge Boyd ensures offenders are held accountable without excuses. Starting with Mr. Contras, a man who failed to comply with his probation terms while facing charges for assaulting hospital staff. Let's watch this.
No, I have it. It
Okay.
was stuck to the paper.
Okay.
Mr. Contras, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented? All right, Mr. Contras, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand you're charged with assault of a hospital personnel? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
In my opinion, he was, Your Honor, and he is.
Mr. Contras, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 8 years in the prison. There's a $2,000 fine. State recommends community supervision. There's to be restitution, if any, to the complainant. Did you understand that to be the plea?
Yes.
Defense is at the plea.
It is, Your Honor.
State is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motion?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 8 years. There be a TAP evaluation, 200 hours of community service restitution, and no contact with the complainant. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Could be contained in exhibit 1 and attached, Your Honor.
All right, state, you may be excused. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, just the court will follow the plea.
All right, how long have you been using?
Like
4 years.
All right. Do you have any other criminal history other than this case?
Yes.
Is it violent history?
No.
All right. What are your other cases?
On theft and dope.
All right. Do you have any children?
No.
If you were released, who would you be living with?
The him bro.
All right. So here's my question for you. You know yourself better than I do. You need inpatient treatment. So the question is whether or not you want inpatient treatment. If you don't accept inpatient treatment, what's going to end up happening in the slow run is that you may end up going to prison for 8 years. But I'm going to have you remain in custody until the evaluations are done for you to go into inpatient treatment. And you need to be honest with them about your addictions. You understand?
So I have to go to inpatient room?
Yes, you're going to go into somebody's inpatient. And I hope you can understand why that's the appropriate thing for you. If you get to the point where you're at a hospital and you're assaulting somebody because they won't give you fentanyl, that's a problem. Now, if you do not want the help, I can send you to prison. If you all want to agree that he goes to prison, and I can send you to prison, but otherwise you need treatment desperately. And what I can tell you, if you choose the prison route, I will follow your agreement and send you to prison. But what's going to end up happening is you're either going to end up back before a judge for other charges because you're trying to get your fix, or either somebody's going to be identifying your body. So, do you need to talk things over with your attorney? All right. So, Vashon, he needs inpatient treatment. Somebody sentenced him to 8 years in the prison, suspended and probated for 8 years. If you successfully complete everything, I'll consider removing you off early, but do not come before me asking for early termination before the 4-year mark, because it's going to take a while for you to get clean and sober. And then it's going to take you a while where being clean and sober becomes a habit. Okay. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. There's to be 200 sober meetings in 200 days. The following will be in custody. There will be a referral to felony drug court. If you're accepted in felony drug court will come up with conditions for you, because that's a place, it's a treatment court, and it's to help you control your addictions, or at least become clean and sober, okay? I'm going to want the TAP evaluation in custody. Follow recommendations. And if he's not accepted into felony drug court, let's have him brought back. When's the last time you had employment?
Years ago.
All right. So how have you been supporting yourself?
Handling.
All right. There's going to be proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. Do you have any family here in San Antonio?
No.
Do you have any family at all that you've had contact with?
No.
All right. Do you have any children?
No.
Do you have any type of support system? All right. There's going to be 200 hours of community service restitution. How far did you go in school?
9th grade.
All right. Is there a reason why you stopped going?
No, I just stopped.
All right. So there's going to be 200 hours community service restitution. 100 of those hours will be deemed satisfied upon completion of the GED, and the other 100 hours will be deemed satisfied if he obtains some higher level education or either some sort of trade school. I'm going to want field visits 1 time per month until further notice. There's to be no contact and restitution, if any, to Brittany Mendoza. There's to be no unsupervised contact with minors. And defendant is not allowed to reside in any home where there are minors. And there's a $2,000 fine, and that will be probated. So if you successfully complete everything, you won't have to pay the $2,000 fine. Probation, is there anything else he needs? Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. In this court, to be successful on probation, communication is key. If you have an issue, let your probation officer know about it. If you feel they're not addressing it, you can still come back to court. And if you feel as though you need more drug treatment, I'm not going to frown upon that. For example, I've given you 200 sober meetings in 200 days. The reason why I did that is because for you, going to sober support meetings needs to become your new habit. And you're going to have to meet new people and go to new places and new things. If you come to me and you say, Judge, I'm at the 201 day mark and I really need some more sober support meetings, I'm not going to say, oh, I'm not going to let you off of probation early because you need more help. I'm going to say thank you, because part of being sober is knowing what you need to do to maintain your sobriety. Okay. All right. Good luck to you.
Just like Mr. Contras, here's Mr. Zuniga facing charges for repeatedly violating drug court rules. It's pathetic how some of these think the law doesn't apply to them.
2023 CR 7894, State of Texas versus Alberto Jose Zuniga. Could I have parties announced for the record for the state? Defense?
For the defendant,
All right, and Mr. Zuniga is on crutches and appears to have difficulty moving. Any objection to Mr. Zuniga remaining in the box?
not from the defense.
All right. Mr. Zuniga, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Alberto Jose Zuniga who was placed on deferred adjudication in 2023 CR 7894 for the offense of possession of a controlled substance, penalty group 2, 1 to 4 grams, on October 17, 2023 for a period of 2 years and extended for a total of 2 years? Is that you? State?
Yes, Your Honor. Say we'll proceed on violation condition number 41. On or about the 8th day of November 2024 in Garrett County, Texas, the defendant Alberto Jose Zuniga did then and there failed to comply with the rules and regulations of the felony drug court in violation of condition number 41. Take the day by other violations.
To violation of condition number 41, how do you plead? True or not true? Did you understand by pleading true to violation of condition number 41, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition 41? And defense, do you have any objection to the state's waivers of the other allegations?
None whatsoever, Your Honor.
Court will find violation of condition number 41 true. Is there a proposed agreement? Yes.
For the defendant to be revoked from his current probation and sentenced to 2 years in the Texas Department of Corrections.
That is the agreement, Your Honor.
All right. Is there a reason why I should follow for him to minimum? He was in felony drug court and he didn't apply by the rules of regulations. So why should I give him the minimum?
Well, he only has 54 days, I believe. So he's going to do, depending on what the Board of Pardons and Parole does, he's going to do at least 4 or 5 more months incarceration. He's never been to TDC before. Marijuana is his drug of choice, and he's just had a hard time kicking that.
Any objection to the court reviewing the court summary?
Not at all, Your Honor.
All right. Let me see if I can find it here.
I believe the DA has a hard copy.
Oh, they send me emails. I have it by email. I
Okay.
just don't open it unless people give me permission and with no objections. All right, so he was discharged unsatisfactorily from IOP. And then he was sent to felony drug court. And he just wouldn't stop using drugs.
Marijuana, correct, Judge? He
Well,
also-
there's I know it's 2024, but there's an admission to cocaine from your client.
Yes,
And then they sent him to Laurel Ridge and he absconded and a warrant was issued. And then it says that he was later arrested for a new felony assault. What happened with that case?
that's gonna be,
All right. And then it says, while he was absconded, he admitted to continued substance use, cocaine and marijuana. And they said, it says here that he's had 2 previous probation revocations,
Actually-
non-compliance with specialty courts. And when I say 2 previous revocations, I don't mean what he's on probation, just in his past.
Thank
Non-compliance with the specialty courts, assaultive behavior, which you all say you're not proceeding on that. So I won't take into consideration where they say assaultive behavior. So I just don't think I don't think 2 years is appropriate. So what I'm going to do is I'm going to sentence him to 3 years in the prison. I'll give him credit for any time served. And I'll request the therapeutic community. And the other case, are you all taking care of that now? Are you taking it into consideration? Are you dismissing it outright? What are you doing? All right. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? All right. You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand? All right, we can go off the record. Here's the thing. You're young. You still have more of your life ahead of you. Take this time to get clean and sober. When you're released from prison, because everybody always says, you know what, I'm going to be on the straight and narrow. I hate prison. I hate the Bexar County Jail. And they come right back. When you're released, you need to find a place for rehab. If you can't find a place, if I'm still here, you come back here, I'll pick up the phone and call someplace to help you, okay? With regards to therapeutic community, it doesn't increase the time that you're on probation. It's something to help you maintain your sobriety and to rehabilitate you. I will let them know in my judgment that I'm requesting it for you, but you're going to have to request it as well. You understand? All right, good luck to you, okay? And take care of your health.
This time, we have Mr. Reyes, who was given a chance with community supervision after being convicted of unauthorized use of a vehicle. Yet, despite that leniency, failed to comply with his probation terms, skipping drug tests, and ended up back in court.
State versus Mark Anthony Reyes. Could I have parties announced for the record for the state? For the defense?
Joseph Uphelt.
Are you Mark Anthony Reyes? Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Mark Anthony Reyes who was placed on deferred adjudication in 2020 CR 10202 for the offense of unauthorized use of a vehicle on May 4, 2021 for a term of 4 years and extended for 1 year?
Yes, ma'am.
State?
On or about the 10th day of January 2023 in Bexar County, Texas, the defendant, Mark Anthony Reyes, did then and there fail to submit drug testing as directed by the supervision officer in violation of condition number 2.
How do you plead to that? True or not true?
True.
And I'm sorry, what was the number again?
Number 2, Your Honor.
All right, I'm making sure I have it.
And the state waives the remaining violation allegation, Your Honor.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, ma'am.
Court is going to find violation of condition number 2 true. Is there a proposed agreement?
Yes, Your Honor. Adjudicate guilt, revoke supervision, assess punishment under 1244A at 120 days.
All right.
If I may, Your Honor.
Yes.
Mr. Reyes has been in custody in Medina County beginning in March of 2023 for a third-degree felony, which he pled to for 6 years, and he was then transferred to TDC, where he was just paroled on December 17th.
That clears things up. So you could read my mind. You were,
You're
you out of my
welcome.
mind.
So Judge, he actually has, and if you need to see it, Judge, I have the conviction by the court waiver of jury trial where it shows that he actually has 370 days actual on the other case in Medina County, which was supposed to run concurrent with this one, but he was never brought over to take care of this motion to revoke. He has, my understanding is 121 actual days credit in Bear County Jail on the case before you, Judge. And that's why we're asking for that credit for time served and for it to be actually judgment satisfied
All right.
on this case.
Because I was wondering, why should I do this? But you've explained things. Thank you. All right. Are you asking the court to follow this agreement?
Mhm.
Are you waiving your right to appeal?
Yes, ma'am.
All right. The court will follow your agreement. The court will find you guilty, revoke, sentence you to 120 days in the Bear County Jail under 1244. Court will show that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, I did.
And I'm sorry, just one other thing. All right, before probation, he had a restitution amount of $8,000 to Toribio Garcia. Was that paid? And that was a part of your plea bargaining agreement.
Yes.
All right, there's to be restitution and no contact with Toribio Garcia. And the restitution amount is $8,000. Yes.
But under the amount due section for restitution, it shows 7,656.
All right, we'll change that. I'm just going strictly by what's in the plea bargain paperwork. So the restitution amount, what do you say, counsel?
Oh, that's the problem. The balance says 8,000. The amount due shows 7,656, and there don't appear to be any credits.
All right, so $7,656. Okay,
I can't explain the discrepancy from what I can see.
all right, thank you. Okay. Did you ever pay?
Dispersed or anything, it states still that the $8,000 still due.
All right, and what are you saying, counsel, that there was, is that amount that the complainant gave to you?
I'm just repeating what I see on the court summary, Your Honor. There's a discrepancy between the amount due and the balance with no credits. So I don't understand the source of the discrepancy.
Just one second. Any objections to the court reviewing the court summary?
Naturally, we like the lower number. It's a $344 difference apparently.
Let's go off the record. Ms. Abrams, do you know if that's the, because on the court summary,
It's how many supposed to be dispersed, how many payments have been made, all of that, and there have been no payments made.
all right. Okay, thank you. All right, so we're back on the record. The restitution amount is $8,000. And that restitution amount goes to Toribio, Toribio Garcia. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
Now it's Mr. Baker requesting leniency after being caught in possession of hard drugs while still on probation.
Yes, Your Honor.
Mr. Baker, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, no,
Anyone promised you anything other than the plea?
no,
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed under 1244 to 154 days in the Bear County Jail. There's a $500 fine and no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Is Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
All right. Any evidence?
Should be contained in Exhibit 1 and attachments, Your Honor.
We reviewed the same, no objection, Your Honor.
State you may be excused.
Thank you, Judge.
Mr. Baker, that mask really doesn't work if you don't cover your nose too. So you got to make a decision. Right now you're in no man's land with the mask. All right. Did you review the document entitled, did they give you a new mask in the back or is that an older mask?
It's an older one.
All right. Do we have another mask for him? We'll give you a new one here.
Okay, thank you.
At some point, I don't think the old masks work.
They don't.
All right, Mr. Baker, did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
We just asked that the court follow the agreement of the parties. My client's been in jail for quite some time. We believe that this is the best disposition for him at this point, Judge.
All right, Mr. Baker, how old are you?
69.
69. Do you have any family here?
Yes.
Do you have a support system or have they just said, he's just doing what he wants to do?
Doing what he wants to do.
All right. Court is going to find you guilty. The court will sentence you to 154 days in the Bear County Jail under 1244. There's a $500 fine, time and money to run concurrent. Court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. I see you have a lot of bracelets on your arms. Is that from the infirmary?
Yes.
All right, so here's the thing. Medical issues and illegal drugs do not mix. Even if you're in the perfect health, illegal drugs don't mix, because there are some people who are in the perfect health. There was a basketball player who had just got drafted. He got drafted by, I want to say the Celtics, Lynn Bias. You think he's the perfect condition of health. Tried some drugs to celebrate. The people who had him trying drugs to celebrate were not his friends. And then, even though he was the first draft pick, all over the news, you know what it was? Lynn Bias dead. That could be you, where somebody's trying to identify your body. So the girlfriend who you were with, you're going to have to cut her loose because you all are using drugs together. And you're going to have to try to get your life in order. Otherwise, one or two things are going to happen. You're going to spend the rest of your life at somebody's Bear County jail or somebody's prison, or either they're going to be identifying a body on the street and somebody's going to come and tell me, my client, Chet Baker, do you remember him, Judge? I'm going to be like, yeah, because my mind's a steel trap. And then they're going to say, well, Chet Baker died. And you know what people are going to say? Oh, well. Hopefully he had a chance to pray before he died. You understand?
Yes.
There are plenty of free places in Bear County and throughout the country now for drug treatment. If you can't find a place, if I'm still here, you can come back here and I will pick up the phone and call for a place for you to go to get help with your drug issues and whatever issues that are going on with you, okay? All right, good luck to you.
Finally, this last case is centered on Mr. Mason facing charges for possession of drugs.
All right, Mason Allen Washington, come down. Yes.
Your Honor, we're here set on my client's possession case. However, the state recently on one indicted a charge that is more serious, Your Honor. We're asking for a reset so that we can get some evidence in the new case that has not come in. Right now, there are only documents available on the first degree, Your Honor. And so I have let Ms. Jones know that we still need body cams, but what happens on the new case is gonna control the state jail that's set before you today, Your Honor.
All right, so do they have all of the evidence?
I asked earlier, I'm not sure if she was able to confirm.
All right, who's the state for Mason Washington? All right,
I'm asking CTD or family violence.
well, there's a drug case that's a possession less than a gram. And then there's some newly indicted case.
It's not indicted. It's fine.
No, it's indicted.
Oh, I'm sorry, I think I missed that. My apologies.
It just got indicted.
Just got indicted.
And that new case, Judge, is the one that we're missing evidence on, and it's the more serious charge.
All right, is all the evidence uploading on that case?
No, Your Honor. Well, I don't know. This was just brought to my attention earlier this morning, so I haven't had a chance to look into it. It appears that we're missing body cam. Typically, there's body cam in these cases. I haven't had a moment to reach out to the detective to determine if that's accurate in this case or not.
Now, Marie called this for February 18th for discovery. Do you have any questions?
No, Your Honor.
All right, we'll bring you back on February 18th. Thank you.
Thank you, Your Honor. May I be excused?
Yes.